Good evening, and thank you for joining this live webinar this evening on behalf of the Tenant Farmers Association. Our topic tonight is From Conflict to Resolution, Lifting the Lid on Arbitration, a Tenant Farmers Guide. Before we get started, I would like to have some housekeeping rules to go through. My name is Robert Martin, and I'm the National Chairman of the Tenant Farmers Association, and this event is kindly sponsored by Roythorne Solicitors. For those that don't know, Roythorne is a national law firm steeped in agriculture. They have 90 years' experience advising landowners and tenants alike. Their lawyers are active in farm tenancy policy groups. They get the bigger picture. So whether it's a succession application under the AHA or an FBT, a dispute with your landlord or a share farm agreement or a collaborative nature capital agreement, Roythorne's is there to advise and assist. If you miss any of tonight's webinar, you want to re-watch it at a later date, it is being recorded, and once edited, you'll be able to view that on the TFA YouTube channel. To find our channel, just search for @Tenant Farmers. The TFA video library features all the past webinar events, knowledge share, teachings, and key news snippets. We encourage you to pay us a visit and subscribe to the channel so that you'll be notified when we next upload our new content. So just search for us @Tenant Farmers. Moving on to this evening's main event. Tonight we're thrilled to welcome Ruth Farrell, a qualified arbiter with over 15 years' experience as a rural chartered surveyor. She is a senior business consultant at DJM Consulting and a TFA recommended professional based in Shropshire. Ruth has extensive experience in dispute resolution and arbitration, specialising in landlord-tenant relationships, valuation, taxation, compensation, and planning and land development opportunities. Ruth is a qualified member of the RICS and British Institute of Agricultural Consultants and a fellow of the CAAV. A further feather in Ruth's cap was awarded the Agricultural Advisor of the Year at the National Women in Agriculture Awards in 2024. Following a short presentation from Ruth, we will be joined by the TFA's Chief Executive, George Dunn, who will be hosting this evening's question and answers. So, Ruth, the floor is yours.
There we go. So, lifting the lid on the arbitration. So, next slide, please. So, this is what I wanted to talk to you all about. I want to just explain what arbitration is and how it works. I want to help reduce the fear factor that we have about arbitration by sharing some of the knowledge that I've got from my practice, and then to give you all some topical tips for running arbitrations or participating in arbitrations effectively. So our next slide will take us on to about me. So I am the eldest of 4 sisters. I'm used to being bossy, and I once cut a smartie 4 ways to resolve a dispute about who had the last one. So some early experience in dispute resolution there. As Robert said, I'm a senior rural business consultant and chartered surveyor at DJM Consulting in Shropshire, and my day-to-day work consists of advising farming businesses about setting and implementing strategy, particularly in landlord and tenant matters. I deal with capital taxation, things like inheritance tax, and adding value to land. But obviously tonight we're focusing on arbitration. So in terms of my journey to where I am now, I did a diploma through the RICS in arbitration whilst I was working. I did that 6 or 7 years ago, and then I was elected onto the CAAV and RICS President's Panels of Rural Arbitrators in 2020. So I've been acting as an arbitrator since then, and I'm also a member of the Association of Rural Dispute Resolvers. So in terms of my arbitration work, I have been the arbitrator in 44 arbitrations so far in my career. I've currently got 13 arbitrations live in front of me as I talk to you now. And I would say I get probably between 5 to 10 appointments a year, and they can come in from all over the country. So not just in my local area. And I would say that my arbitration and dispute resolution work probably takes me on average across the board about 1 day a week of my time. So let's dive into what is arbitration on our next slide, please. So arbitration, it's a form of dispute resolution which is an alternative to litigation in court. And that's where we get this phrase, alternative dispute resolution. And it is the default dispute resolution provision in tenancy agreements and in the governing legislation for Agricultural Holdings Act tenancies and FBT tenancies. It is an adversarial process which pits the parties against one another, and this is common in most forms of UK dispute resolution. The arbitration process is governed by the Arbitration Act, which is what gives me my powers to do what I do in terms of managing the parties. And the process itself is private and confidential. And so nobody other than the arbitrator, the parties, their agents, their representatives know about what happens within the arbitration, with the exception of if an award gets appealed. So court what happens in the courts is a public process, and anything that ends up in the courts could end up in the public domain, but that isn't very common. And the things that arbitrators generally get asked to decide are the facts of the matter in order to reach a decision. So that's what we're most commonly dealing with. We're dealing with matters of fact. We occasionally are asked to deal with points of law. So how would the law be interpreted in a particular way? But most commonly we deal with facts. And my last point on there, it's a legal process. It's very closely related to court work, and there is crossover within arbitration and court work, and one can refer to the other. So it is a legal and serious process. And that takes me neatly on to my next slide, which is about the duties and behaviour of everybody that's involved in the arbitration. So again, we find these in the Arbitration Act. And what that says is that the arbitrator has to do the following things. So we must act fairly and impartially between the parties. So that means we mustn't favour one above the other. And there are steps that we take to make sure that doesn't happen. So for example, as an arbitrator, you would never have a telephone conversation with just one party. You would always make sure both parties were in the call, or if you had a meeting, both parties were at the meeting or had the opportunity to come to the meeting, that sort of thing. And all correspondence that I send out to parties in arbitrations is always copied to the other side, and I expect them to do the same when they write to me, and that just keeps everything open. Arbitrators are obliged to give each party a reasonable opportunity to make their case. So that's sufficient time to put forward their statements of case, and sufficient time to deal with the cases of the opposite party. And we're all obliged to adopt procedures rather that are suitable to the circumstances. So if you've got a relatively simple dispute, you'd have a relatively short arbitration, and obviously vice versa for something more complicated. And there's an obligation on the arbitrator to avoid unnecessary delay or expense. So quite often we're chivying the parties because that's part of one of our duties. And equally important as the arbitrator's duties are duties in the Arbitration Act that the parties must adhere to. And I set this out to the parties in my first letter that I write to them and say, this is what you are expected to behave like during this process. And the parties are obliged to do all things necessary, this is the proper phrase, for the proper and expeditious conduct of the arbitration process. So they must cooperate, they must help the process along. And one of the things that they must do is comply without delay with any determination that I make as the arbitrator. And there are cost implications, which I'll come on to later, if people fail to do that. So there we go. So that leads me then on now to talk next about the process of arbitration. There we go. So an application is made for the appointment of an arbitrator. And at the moment, that can be done through 3 routes. So we've got the RICS. You can apply to the RICS Dispute Resolution Service for appointment of an arbitrator. It can be done also through the Central Association of Agricultural Valuers, the CAV, and the Agricultural Law Association also has the ability to appoint arbitrators now. That was something that was changed reasonably recently. So the application is made to one of those bodies. They then they approach an arbitrator and say, can you act? Have you got any conflicts? And we do our checks and say, no, we don't. And we're then appointed. And the arbitration process, it begins on the date of that appointment. So when I write to the parties, which I will do a day or so after I've been appointed, we are already in arbitration. The arbitration has started. And so I write to the parties, I set out the position, what I think I'm there to deal with, explain what my fees are going to be. And one of the questions I always ask is whether the parties need more time for negotiation, and if so, how much they need. And it's very common that parties will say, oh, yes, please, could we have a month, 2 months, 3 months, whatever. And that's absolutely fine if both parties want to do that. But if the parties aren't able to get any further between themselves, or when we get to a point when that happens, then I will set a timetable for the arbitration to proceed through the steps of statement of case, exchange of evidence, and things like that. What I tend to find is that most matters are settled between the parties before I have to take a great deal of action, but equally some arbitrations require a lot of action and a lot of awards. Sometimes parties, when they come to an agreement, they will ask me to do what we call an agreed award. So that's an award which records the agreement between the parties. And that is something that is quite important to understand about arbitration awards, which is that they have a legal standing of their own, in the sense that if one party doesn't do what the award says they must, then the other party can take the award to the courts for the court to enforce it. And that's one of the reasons why arbitration is a useful process for people, because a definitive enforceable answer is got to at the end, and then everybody can move on from that. And that isn't always the case with other forms of dispute resolution. So time scale and timetable. Even simple arbitrations can take months. That is one of the things about arbitration. And with the parties needing more time for negotiation, trying to get dates in the diary for meetings, exchanges of evidence, setting that round holidays, etc. So if you're in arbitration or you're going to enter arbitration, do be prepared for it to take quite a while. Complicated ones do take years, especially if we've got things like preliminary issues that need to be sorted out before the main matter can be addressed. And the kinds of common cases that I deal with in terms of matters that come to arbitration, rent reviews, obviously, also unwritten tenancy terms, dilapidations and end of tenancy compensation matters, and notices to quit given on various bases. So those are the kinds of things that tend to come in front of us as arbitrators. And what I have found as a useful analogy to explain to people about how arbitration works and the role of the arbitrator is set out on my next slide. And I call that the glorious game analogy. And by that, what I mean is that arbitration and the role of an arbitrator is very like any game that's played on a pitch. The arbitrator effectively acts as the referee. They set the rules of the game if the parties haven't already agreed them. They work out where the edges of the pitch are, and they watch over the parties for the timed duration of the game or the match. But it is the parties that have to actually play the game, score the points, score the goals by providing evidence to the arbitrator. And the arbitrator doesn't at any point descend onto the pitch and play the game. And equally, the game doesn't work if the parties don't play. And then when the game or the match is finished, the arbitrator decides who's won. And the quality of the goals that have been scored, or the points that have been scored, help the arbitrator to decide who has won. And then after the winner has been declared, the arbitrator then considers the behaviour of the parties during the game when considering who should pay the costs for that game. So I find that quite a useful analogy, and you'll understand why when I come on to explain about the pitfalls of arbitration that I see, or the common misunderstandings. So next, I'm going to whiz on and talk about costs. That's it. So it's something that we're all familiar with, but arbitration is expensive, and it is expensive because it's a serious semi-judicial process that takes a lot of time and involves multiple professional people that charge for their time spent at hourly rates. The default position in terms of the treatment of costs at the end of an arbitration, once you've reached the end and dealt with the substantive issues, is set out in the Arbitration Act. So it's in the law. And the default position is that the costs follow the event. And what that means is that the winner effectively deserves to have their costs paid by the loser. So the loser will pay the winner's costs, the arbitrator's costs, and obviously their own costs. So it also becomes expensive if you lose. And what happens in terms of costs is when we get to the end of the substantive issue, the parties will make representations to me, to the arbitrator, about how those costs should be treated. So one party is always saying, yay, we won, can we have our costs, please? And then the other party will write and say, well, you shouldn't award them their costs for the following reasons or for these sections of the arbitration. And then I consider that view. And there are ways that costs can be managed at the start of the arbitration and during the arbitration. It's much less easy to manage them when they've been incurred. And so ways that we can manage those costs is by agreeing to adopt a suitable process at the start. The parties actually have the power to agree to costs being capped for the whole or part or some of the arbitration. And as an arbitrator, we have powers as well to impose cost caps. But those caps do apply to recovery of costs, not to the level of expenditure the parties can make. They can spend what they like, but we would cap on what they could recover. And then the other way the parties can manage their exposure to costs is using Calder Bank offers to try and reach a deal, which then come in front of me at the cost stage if necessary. So the scale of costs is a massive issue in arbitration. And after sometimes you can find they become a bigger issue in the arbitration than the cost of the matter that the parties are in dispute over. And sometimes that happens because the parties and their representatives are not familiar with the process and they leave the arbitrator to chase the parties for responses, and that incurs costs. People are scared of arbitration, so they use very expensive representation to try and help them with that. But what I would say as a general message to everybody is, if you have good and sufficient evidence, how expensive your representation is unlikely to make as much of a difference as you think it might, because the evidence is the important thing in any arbitration. And the other thing with any adversarial dispute resolution process is that once you're in the process, you even raising the white flag, if you think, oh, we've had enough, we want out of this, it effectively counts as losing in the eyes of the court or in that legal process. And that means people end up being forced to keep going in the hope that they win and can recoup some of the costs that they've been exposed to. So one of the big risks with arbitration is always, can you afford to lose? And that takes me on to the pitfalls of arbitration. There we go. So I think in terms of sort of issues that I tend to find come up again and again is parties not understanding what arbitration is and how it works. And I keep referring to parties, and by that I mean either or and the agents that are acting for the parties in the dispute or the parties in the dispute themselves. So I do include agents in this as well when I talk about parties. So we've got also the other thing that parties do is they don't follow directions. Now, directions are instructions that are given by the arbitrator to the parties to do things by a certain date generally, and parties don't follow them. Another pitfall is parties assuming that they can't do something until the other party has. And I just wanted to raise this particularly in this forum because I find it's a trap that tenants in particular fall into, because they kind of wait for the landlord to put their case forward and then decide what their case is after that. And that there's absolutely nothing stopping. And in fact, I would expect a tenant's advisors or to put forward their case as well at the same time. And then the other thing we have is people do misunderstand the arbitrator's role, which is why I think my game analogy is quite helpful. We are not all seeing. We only see what is put in front of us as arbitrators, so we only see what is submitted, and we cannot, and we do not go beyond that. We're not allowed to step outside those bounds. So if you don't give things to us, we don't know. We don't know that they're there. We don't know it's a factor. We don't know it exists. We are working professionals. We're managing busy caseloads, and I don't obviously do arbitration all the time, as I've said. So our role is to put the mechanism in place for an even-handed exchange of evidence, and then to assess that evidence impartially. And the more help we get from the parties in doing that, the easier it becomes for us to reach a decision. And then the final and sort of almost biggest misunderstanding is the parties' role. And the Arbitration Act is very, very clear that the starting position is always for the parties to set the process that they want to set. And one of the most common things the Arbitration Act says is, unless otherwise agreed by the parties. And I've sort of say that in inverted commas because that's how most of the clauses start. So unless otherwise agreed by the parties, the arbitrator has the power to. And what that means is if the parties agree something, then the arbitrator has to go with it. So if the parties said, right, we only want to have 3 pages of submissions, fine, that's what we do. And the parties do have that power. But what I find is parties seem to think that matters are taken out of their hands when they've been put into arbitration, and that's simply not the case. So just bear that in mind. So next slide then, we're on to rent reviews. These are a nice subject really to have in arbitration in terms of process, because they are familiar to everybody that's involved. There's a formula to follow in determining the rent, particularly in the 1986 Act tenancies. And indeed, the 1986 Act legislation actually tells the arbitrator what to do when considering a rent review, so that's always helpful. And rent reviews start with statements of case from each parties after we've gone through all the appointment preliminaries. And then in that statement of case, we would expect to see any relevant information about the farm, the terms of the tenancy agreement, the level of rent that you think should be paid for the farm, and the evidence that you rely on to reach that view. And I know that sounds obvious, but people do put evidence in front of me. I had one case where somebody put some expert evidence in front of me and kindly explained very clearly what the rent for the arable land on the farm should be, and just said the grassland should be less than the arable land, and gave me no explanation as to why, and no figure for what rent should be applied to the grassland, and which left me with nowhere to go, obviously. So in those sorts of circumstances, then you only have one side's evidence to rely on. And one of the things I probably ought to point out at this stage really is that as the referee in my glorious game analogy, I can use my knowledge and experience that I've got from doing my job to decide how much weight to apply to what the parties tell me. But I'm absolutely not allowed to use that experience to guess at what the parties mean or to extrapolate what they're telling me into something else. So, I have very, very clear boundaries in which to operate. So back to what we deal with in rent reviews. I would say an important point is to make sure that you submit evidence that does match what the rent review provision says should be put forward. So budgets, if you're doing an AHA rent review, and comparable evidence for both AHA and FBT rent reviews, etc. And you can see on my slide there, I've got a extract from one of the TFA's guidance notes, and that's a useful note for setting out what to expect in terms of the process in arbitration at rent reviews. So once we've had all the statements of case, each party then gets a period of time to review their opponent's case and make any counter comments that they want to before I consider the cases. And I will visit the subject farm and may visit some of the comparables as well before reaching my conclusion. So that then takes us on to the nearly last slide, second to last slide. So I thought just perhaps summarising with a few hints and tips really for how to things to think about in an arbitration, and I've set those out in terms of things to think about before an appointment. And you can see what I've got there. Number one is take it seriously, and so that it is a serious process. Do engage with it. So do establish what your own case is, what you think your rent should be, and don't wait for the landlord to make a move. Because if you do go to arbitration, you're going to have to put your own case forward, and might be relying on completely different evidence to what the landlord is going to do. And actively engaging early might avert the need for an appointment and just give you an idea of how successful your case is likely to be. Back to my point about can you afford to lose, which is at the bottom of the slide as well. And then, thank you, Julia. So after the appointment, just bear in mind that the conduct of agents can affect the costs award that the parties receive at the end, because and that is the agents reflect upon what the parties are doing effectively. So I take their word as your word, as it were. Do remember to explain your case in a straightforward way, and it's something that's very easy to miss if you like the basics, because you have to remember that the arbitrator doesn't know the farm, hasn't seen it, is looking at a flat map. So if it's steep, make sure that's put in there. Just tell the story of the farm. It's important that we can build that picture up when we're considering the papers, particularly before we've been out to see the farm. And then in terms of the arbitration process, the rules and the behaviour parties that I set out at the beginning, they are there to guarantee a fair process. It is not necessarily a fair outcome, and that's something I think parties should bear in mind when they think they want their sort of proverbial day in court. The outcome depends on the evidence. Evidence. That's the biggest thing about any arbitration, is how good is your evidence, because that's what the arbitrator will rely on to determine the facts. And then finally, try and remember that this is a business transaction. And I realise that this is an easy thing to say and not an easy thing to do, but people do take it quite personally, and they end up burning quite a lot of emotional energy, which is exhausting for everybody and doesn't help anybody's health. So yeah, do try and remember that for both parties, whichever side of the table you're on, it's a business transaction. So that brings me to the end, I think, of my points and things to raise with you all. So over to George for questions.
It's really, really great to have you tonight, because it's not often that we get this sort of insight into the arbitration process. It's a bit like the magic circle. You arbitrators hold this stuff in your hands, and because it's a confidential process, it's very difficult to get a look in to see how something goes. And a bit like Robert, you just end up there and really have to play it as it comes. And you said in your remarks that the process is adversarial.
Mm-hmm.
And from my perspective, I think it gets particularly adversarial when solicitors become involved and you have that sort of courtroom drama played out in an arbitration. But what advice could you give to parties so that we can get to a position where the process delivers more light than it does heat?
Okay. So one of the things I think that all parties can do is make sure that you identify the issues succinctly, so that the arbitrator can really focus only on what is in dispute. And there is a tendency with any arbitration, and a little bit like coming back to the point I said about if you don't tell us, we don't know, there's a tendency to throw the kitchen sink in. And I think there's also a tendency, once parties are in arbitration, for the parties perhaps not to engage as much as they might, because they think the arbitrator will now deal with everything. And so what is useful is if time is spent on narrowing the issues. And as an example, when I first write to parties, I ask them for a description of what matter is in dispute, and everybody writes back and says rent, but that's not actually what they mean. It will be some part of the rent review process that's in dispute. They'll either be arguing about productive capacity in an AHA, or they'll be arguing about how arable, how many acres of grass. There'll be something else that's stopping to the level of rent, and really that's what I mean by focusing on the issues. So that's can help do that. Try and use agents and solicitors for a history of between themselves. That processes down and to the adversarial nature. You can ask the arbitrator to direct to make sure that parties must remain. So that's something that I put in my sort of important information about the arbitration. I make sure my first set of directions, I would make sure that was in there as well. That you conduct themselves unprofessionally, and keep negotiating outside the arbitration. There's nothing to stop you carrying that once we're in arbitration. And then the other thing people can do is adopt rules below, which stops things ballooning a bit as well. So those are the kinds I would say, George, and light and heat. Oh, I've gone and lost you again now. Oh, you're...
Hello, sorry.
There we go. I've got
Sorry.
you back.
Yeah, sorry, apologies. Yeah, we're all having technical issues tonight. I do
It's like a
apologize.
Friday, isn't it?
Okay, so we talked about the adversarial nature of the process. It can also be a very expensive process, and I know there's a question in the Q&A about the cost side from Mr. Hawkins and the cost of an arbitration against what a farmer might be earning from the land that they are farming. And you did talk a little bit about this in your remarks, but how should the parties prepare to ensure that the process doesn't run away and it is a cost-effective process to get a dispute resolved?
Yeah, I think kind of the biggest answer to that is keep communicating. Don't stop the lines of communication. Deal with things quickly and keep communicating between the parties as well as with the arbitrator. That proactive participation is a great help for keeping costs down. Back to the point I raised earlier, really about identify the issues succinctly, so the arbitrator is only dealing with what's actually in dispute, and quite often we will have to do a statement of agreed fact so that we can see, we can work together on that. Keep it professional into a slanging match, which we see from time to time. And the other thing that you can do in terms of costs is agree to follow where costs are capped, or agree to costs for a certain set of arbitration. So we could cap costs, or we could cap costs for submissions, or the length of submissions, and the parties can agree to between them and tell me that they've done, or it's something that they can ask me to do and I will do for them. And just think about what you're putting in front of the arbitrator, because we have to read that's submitted in order to give to our duties to give everybody a fair chance to put their case. Think before you send it, does the arbitrator do this? So those are the kinds of things I would think to make it as cost possible, really.
Okay, and one way in which the costs can be controlled is if the parties and the arbitrator agree to use what I believe is called the simplified arbitration approach, which the RICS has been promoting recently. Can you say a little bit about the simplified scheme and if it's something that you've encountered and whether you're getting more requests to use the simplified scheme?
So I have encountered it, yes. Most of my arbitrations that start off don't start off in the simplified route. So I'll explain a bit about what that is first before we talk about that. So the simplified arbitration service is simply a pre-designed process of rules, basically, that the party arbitrator agree to follow from the commencement of the arbitration. It's still a full arbitration. So all of the steps that you would see generally in an arbitration are the same, but the rules mean that the process is kept tight, and therefore that can be more cost effective. And it's used for resolving straightforward disputes like rent reviews where there aren't any points of law or preliminary issues or interesting technical challenges that need dealing with. And how it works is that the arbitrator agrees to cap their charges at 3 days worth of work, 4 days if a hearing is required, at a cost of £1,000 a day. So the party's exposure to the arbitrator's costs would be a maximum of £4,000. And one of the rules as well that the parties under that service is that the parties will share arbitrator's costs equally and that they will each be responsible for their own. Under those sets of rules, regardless of means, nobody gets their cost. They just pay the arbitrator's costs and their own. And so have a timetable that the arbitrator will produce the award with working days of the last written submissions from the parties. So it's a really good scheme because it takes the heat out of the mix and can level the playing field in terms of parties' representations. I will always tell the parties about it when I first write to them and say, is this something you're interested in following? And I would think probably of the arbitrations that come in front of me, less than 10% would go down the simplified route. But more of them probably could.
Okay, that's really, really helpful. Now, just diving a bit into the Q&A that we've got tonight, and this is a question which quite often gets raised about the partiality of certain arbitrators, and there's a question about what happens if you get an arbitrator who has got a known history, or you think they've got a view, or sometimes it's just pot luck and you might not get one that you think is going to do a good job. Is there anything you can do about that or to mitigate against those sort of circumstances?
So yes and no. When you are approached by an appointing body as to whether or not you're able to take on an appointment, the things you have to consider are whether you have any actual conflicts, and we have a list of things that we look at. We have we have like a traffic light system. So there's a set of scenarios. Some of them are red scenarios, which means you can't act in that case. Some of them are orange scenarios where you could if the parties were okay, and some of them are green scenarios. And so if you've got a historic involvement with the estate or with the farm in particular, and it's a recent involvement, then you wouldn't be able to take the appointment. If it was an appointment way back in the past, or it was somebody else in your firm, you might be able to take the appointment. So there are all sorts of things like that we have to deal with. And so there is an onus on the arbitrator before they are appointed to make sure that they feel that they know they're not conflicted and they feel that they can act impartially. And the other thing we have to be careful of is, as well as actual bias, is whether there's any perceived bias. So if appointment comes in front of me, and even if I can tick all the boxes on the conflict of interest checks, but I felt there might be a perceived bias because of my involvement or my firm's involvement in something else, then I would think very carefully before taking that appointment, and that onus is on the arbitrators to do. Once you've got an arbitrator appointed, it's pretty difficult to get them removed unless you can sort of prove bias, and parties can put matters into court about the appointment of an arbitrator, but it gets very expensive, and you do really need some fairly serious evidence of bias happening in order to do that. So that is one of the issues I get, well, not one of the issues or factors of arbitration, is you do have a third party arriving in the middle of your dispute who might have a different view from both the parties, and you do end up with that third view in the mix as well. So that's something to bear in mind when you're thinking about going for it.
And I suppose, Ruth, as well, there's the opportunity for the parties, rather than applying for the appointment of an arbitrator, to agree an arbitrator.
Yeah, absolutely.
Between them, and therefore you can, in a sense, circumnavigate your way through those potential conflicts and appoint someone who you know is completely impartial.
Absolutely. Yeah. You can take a private appointment. Yeah. And that does happen, actually. Yeah, that does happen. Yeah.
Okay, so a question here from somebody who you might know. Mr. David Meredith asks a question about whether it is possible to put an arbitration on hold.
Yes, it is, and depending on at what point you want to put it on hold, there are two different ways of doing that. So, if you want to put an arbitration on hold before the arbitrator is appointed, and you're applying for the appointment of the arbitrator through the RICS, then the RICS have a process where you can make the appointment, which means you've met the timetable under the relevant acts in terms of appointing the arbitrator before the expiry date of the rent review notice. So you can make the application and then also ask for the arbitrator the appointment to be put on hold. And what happens then is that the dispute resolution service at the RICS, they effectively sit on the application and they don't write to anybody and say, would you like to be the arbitrator? So, but you have to do that before the arbitrator has been appointed, because as I said before, once I've been appointed or anybody else has been appointed, you are in arbitration and you cannot put it on hold via that route. So if you want to put an arbitration on hold after that, then what you have to do is ask the arbitrator to put a stay in place. And what that means is the arbitrator will stay their activity in proceedings. So the arbitrator won't do anything for a period of time. And ordinarily, if both parties are agreed, they would like a stay and they're agreed on the period, that's not a problem. If you've got one party who would like a stay for whatever reason and another one doesn't, then it's at the discretion of the arbitrator as to whether matters carry on or not.
And that speaks to another question that we've had in the chat, Ruth. This is from Adriana, who says, in circumstances where you've got a landlord who is protracting the negotiations and keeps asking the arbitrator for extensions, and the case isn't proceeding, but costs are obviously increasing. What can we expect an arbitrator to do in those circumstances to ensure the proceedings do move along?
Well, I think it depends on the view the arbitrator has taken in the arbitration on either what's going on or what the parties are doing. But you can absolutely write to the arbitrator and say, you need to take control of this and to do something about this, and set out what you as the party would like to happen next and why, in order to try and make the arbitrator move things forward if a continuous run of stays isn't an appropriate thing to do in the circumstances. Okay,
and just thinking about the rent review arbitrations, which you said were a good place. A rent review is a good example of where an arbitration is quite useful. So when you're in that process of a rent review arbitration, what makes a good statement of case in the eyes of the arbitrator? So when you're looking at those initial documents, what are you really looking for a tenant to be putting into that statement of case?
So to tell the story, I really want to understand what makes that farm different to the comparables that have come in as evidence. I really want to understand what the rent is that people want me to award them, and I really want to understand why. So I want to be able to follow the story of what should the rent be and why should the rent be that. So it's difficult to say, I'd like to see this letter and that letter and this tenancy and that tenancy, but I don't necessarily need to see the whole tenancy agreement, but it might be important that I see the repairing obligations in the tenancy agreement, for example. So it really is circumstance specific, but it's helpful. It's necessary, but also helpful if we have the rent and the reasons as to why you think. And it doesn't have to be millions of reasons, but I just have to be able to follow your logic, sort of show your workings, I suppose, is what I'm trying to say, really.
And before parties come before you, Ruth, as an arbitrator, what would you have expected the parties to have reasonably done in terms of their negotiations prior to coming before you, in terms of providing evidence to each other, and whether the party initiating the rent review should have done more before the arbitrator was appointed? So what would you be looking for to see what the parties had done in advance of coming before you?
That's a difficult question, because the in theory answer is I'd like them to have engaged and just exchange correspondence and exchange their cases effectively in not in draft form, but each party understands where the other party is and knows what what case they will have to answer. But of course, the reality of working life is, I know it doesn't happen like that, and which is why generally people will ask for a stay at the beginning of a rent review arbitration. But in an ideal world, what I would like to see people doing is agents getting together, working out where the areas of issue are, because I think a lot of people end up in arbitration without understanding what their case will be, particularly where you're waiting for another side to do something. And I think what I would like to see is a bit more proactive engagement from both sides of the table with what they think the rent should be. And often that will determine whether or not arbitration is necessary, really.
Okay, so this is a question from Ben Mortimer. So you're in the throes of an arbitration. you've got all the paperwork and the parties are presenting their cases and cross-examining each other, and there's an allegation of dishonesty or underhand behavior from one of the parties about the other party. How do you handle that as an arbitrator? How do you resolve that issue in an arbitration on the day?
Well, thankfully, I've never had to do that. So that's the first thing I'd like to say.
Yeah.
I think I'd have to understand about the allegation and then back to my, if you like, general duties, as well as giving the parties the opportunity to understand their case. I would want to understand why one side thought that and what the other side had to say in response, really. And then, depending on how severe the allegation was, that might, what happens if we were in a hearing, and that what happens in the rest of the hearing. Often when you to hearing, you'll set an overspilled when things might run over, so it might be we'd need to adjourn for a period or whatever, and it depend on how serious the allegation was, really, and what it to, because it might mean one of the parties wants to reconsider their representation as a result of that, and I think people would need the opportunity to be able to do that.
So just in terms of that point on conduct, then, and the issue of costs arises in terms of an award, and this is a two-part question, if you like. So there's a question in the Q&A about what's known as call-to-bank offers, where people put in an offer which is without prejudice sale as to costs, which means that you don't get to see it before the hearing takes place, but you do get to see the offer when you've made your award, so you can decide whether it's a win or not for the party who made the offer. So firstly, how do you treat call-to-bank offers? Does it have to be clearly over the line, or do you look at near misses in terms of a call-to-bank offer that someone has made? And how do you address the conduct of the parties where you think someone has actually won their case but has behaved abominably, and particularly in respect of the new landlord and tenant code of practice that we've got in place? What role might that play in your decision over costs, as well as looking at a call-to-bank offer? I know that's a bit of a complex question, but hopefully you'll be able to give us some insight.
Okay, so the first part of your question in relation to call-to-bank offers, they actually don't come up very often, in my experience. I'm a bit surprised by that, really, but perhaps parties serve them and then do a deal, and then they never see the light of day. So they don't very often. And I think in terms of the near miss point, either something I would establish with the parties in discussion with them. How would they like me to deal with that? Have they got any view one way or the other? And then I would sort of have at that point, really, when those things in front of me, which I've not had to do yet on call-to-bank offers. And then in terms of dealing with unreasonable behaviour, so those are the things where if somebody's not complied with my directions, or they haven't got any good reason for not doing that, or they're bringing points into play that don't have any bearing on things that are there, or very occasionally people will deliberately put without prejudice correspondence in to the arbitration. So when we have people doing things like that, then I have got the powers to issue orders against the party. So something called a peremptory order, which are what we call unless orders. So unless you comply with my directions, I will do the following. So they act like a stern warning, and sort of more serious than directions, really. And I can tell the offending party that I won't rely on their evidence. So if they misbehave too badly, I can say, well, I'm not going to pay any attention to what you're saying. If they're not engaging, I can tell them I'm going to draw adverse inferences from their silence, and in some cases I can proceed to an award without parties putting in evidence if they're not playing the game, as it were. I've talked about cost control and things before, and I think that the code that you referred to, George, that is very important for all professionals, and I would take that into account when considering parties' behaviour, against that code when I was considering costs at the end of an arbitration, and I would have absolutely no problem at all with either party pointing out non-compliance with the code if that was what they wanted to do in their cost submissions to me.
Yeah, thanks, Ruth. I mean, the code exists, and we've been working hard to promote the code. So it's really good to hear that you, sitting as an arbitrator, would take that code into serious consideration when you were awarding costs if the parties hadn't abided by that code. It's really, really, really helpful, and it's really important that people get to know and understand the code and to promote it as widely as possible. Steve Bumstead asks a question in the Q&A about whether you think actually mediation might be a better approach to take to arbitration in terms of disputes, or whether mediation might be something you could hold in advance of an arbitration, so you only arbitrating on those issues where there's a real difference of opinion. What's your view about that?
So I think mediation is great as a form of dispute resolution, but I also think that it will work in some cases and won't in others. So it very much depends on the nature of the dispute. And what mediation is really good at is reaching a conclusion that isn't available to me as an arbitrator. So an arbitration process is very black and white. It's dealing with the particular dispute between the parties. But if there's something else that's in the mix, or a deal could be done wider than the jurisdiction of the arbitrator, so something that didn't just focus on the rent review, for example, if that's what I've been appointed to arbitrate in, I couldn't bring in anything else into that arbitration. Whereas a mediation, it can be very wide ranging and deal with all sorts of matters and issues. So they can be really good from that point of view. And they're private, so they generally cost a bit less than an arbitration does. They can be done more quickly, and if the parties agree that the mediation outcome will be binding upon them, then that's a pretty strong position to be in. As to mediation immediately before arbitration, I think that depends again back to what the dispute is about, really. And in some cases, especially if it's a point of law, it's very difficult to resolve those sorts of things at mediation rather. And they're better taken straight to arbitration, really.
Okay, we'll have two more questions, and then I'll hand back to our national chair to say goodbye and to let you off the hook, Ruth, at that point. One point on proportionality within arbitrations, which I know is something as an arbitrator you've got to take into consideration. So let's say we have a rent review, and the difference between the parties is £2,000 or £3,000. That's the difference in terms of the rent. But going into this arbitration, it's going to be the costs of both sides and you together is going to be £40,000 to £50,000, given who's appearing before you. How do you guide the parties in terms of that in looking at proportionality with the system?
So that's a common, George, that what you've just outlined, as I'm sure everybody can imagine. And it's really difficult to deal with cost proportionality after the costs have been incurred, because of the principle set in the Arbitration Act that the winning party is entitled to their reasonable costs. So in terms of proportionality, it's best addressed at the beginning, and I could perfectly openly have the conversation that effectively the question that you've just asked. I could have that conversation with them and say, look, this is the position. What do you want to do about this? Would you like to agree to cap costs for a period of the arbitration? Would you like me to issue directions that submissions are limited to a certain length, or we're only allowed so many witnesses or so many experts? So all those sorts of things can help with proportionality. There is some things I can do at the end in terms of looking when I review the costs, and I can apply a percentage reduction with reason to cost recovery to reflect the reasonableness of the costs that have been incurred. But it really is better to try and do it at the beginning by the agreement of the parties, because, as I said before, the parties are in control of the process. It is up to them how they run the arbitration, and the arbitrator steps in and set the rules if the parties don't set them themselves. So it's keep talking and try and manage it at the beginning, and that's where the simplified service is very good, because it takes the heat of the costs, out of issues. And if it's a real point of principle in the example you've given, that there might only be a part by £2,000 or £3,000, but it's a real point of principle that people would like to see decided, then agreeing rules like the simplified service rules, which may not apply to the arbitrator's costs, but might apply to the parties' costs. If each party agrees to pay their own, that can go a long way to making costs more proportional in arbitration. So at the beginning, ideally, is the short answer to that question.
Okay, so last question from me. You'll be glad to hear, Ruth. So we're expecting at some point the DEFRA will announce the appointment of a new commissioner for the tenant farming sector. And one of the roles of that commissioner will be to look at arbitration and to see whether there's anything which could be done to streamline the way it operates and to provide a better service. So if the commissioner once appointed comes knocking on your door to ask for ideas around how the process of arbitration could be improved, what will you be saying to them? And one thing I'll just throw into the pot that you might want to consider is, one of the things that I am concerned about as someone who watches arbitration and advises members about arbitration is the confidential nature of it, and the fact that arbitrators can't learn from each other in terms of the awards that they're making, or the decisions that they bring, or there's no precedent like you have in court. And whilst there might be a need to protect the confidentiality of the parties, is looking at the confidential nature of the process something that we could think about, and maybe the commissioner could have a role in terms of bringing that to into a more open environment.
That's a good thought, and I think if anybody could do that this is the opportunity at which to do it, with the tenant farming commissioner in that sort of a role, and I think it is a bit secret squirrels, the arbitration process, and even as an arbitrator, I don't see other arbitrators' awards. It's not like we all pass them around in a little club and say, "What have you done?" It doesn't work like that either. So it is difficult. In terms of ideas that I would perhaps put into the ring, I think education about arbitration and more familiarization within the industry and on farm with it would be quite good, because in terms of rent reviews, for example, those are something that happen on some estates every 3 years, and there's certainly it is a legislative position to allow that to happen. So it should be something that farmers and landlords are familiar with, as a concept and as a process, and both sides have got the right to take matters to arbitration at various different points. So it shouldn't be as secret as it is. So I would think education, training, and possibly, yes, there would be scope for some more openness, and also I think maybe more sets of procedural rules or guidance for the parties as to what the arbitrator will expect them to have done before they get into arbitration. That'd probably be quite useful for people. Just them along, because what fundamentally you have people end up in, they don't know what they're doing, and that's what costs. So anything we can try and improve that would be good.
Well, I think that's a great point to bring our evening to a close, and I think you'll agree it's been a tremendous insight into arbitration. It's something, as I said earlier, I've been through. I don't particularly think I'd like to go through it again, but it was a means to an end. As ever, we've had more questions than we've had time to go through this evening, and Ruth has kindly agreed to go through them and put them up onto the website into the member section once we have time to do so. So thank you to tonight's speakers, to Ruth Farrell and also to George Dunn, as well as to our sponsor this evening, Roythorn Solicitors. And before we sign off, I would like to mention some other TFA events that are coming up, and I'd like to mention the next webinar we have is going to be held on Tuesday, the 3rd of June. What does it mean to have a quiet enjoyment of the holding? This will feature our expert guest speaker, solicitor Harry Russell from Roythorn Solicitors. And finally, for those who are attending the Royal Cornwall Show this year, we have a small number of one-to-one meeting slots available with our Chief Executive, George Dunn, either on Thursday the 5th or Friday the 6th of June. Anyone interested in a meeting with George should contact the TFA office and ask for Julia. And if you can say which days you'd like to join George, that would be great. And I'd just like to hope you found tonight's discussion enjoyable and insightful. And thanks for joining us. And we hope that you'll join us again next time round. Good night.